Hello, I'm Mike Jackson, Vice President of Public Policy and Research at WERC. And joining me here today is Justin Parsons, partner at Erickson Immigration Group and a member of WERC's newly formed U.S. Immigration Rapid Response Task Force. And we want to talk a few minutes about the Laken Riley Act, which was the first piece of legislation passed by Congress that was signed into law last week by the Trump administration, and talk about the act and what it might mean for talent mobility. Justin, can you give us a bit of background on the Laken Riley Act and how the
Yeah.
act came about?
Yeah, Mike. So thanks for having me on today. So I think a lot of folks probably are aware of the name through you know, kind of what had happened over the course of the presidential election last fall. So the bill is actually named after Laken Riley, who was a nursing student, and she was unfortunately murdered in February of 2024, so last year, by an individual who came here, and he was undocumented. Um, so that I'm not going to kind of go into the facts in terms of that, but the allegations were that this individual essentially crossed the border. He'd been, cited in New York City for, riding, I think it was a scooter without a license, and then he was arrested and then let go for shoplifting as well. And then goes on to allegedly then be involved in the murder of Laken Riley. So fast forward really a month, and that's when we saw Mike Collins, who is a representative from Georgia, introduce a bill called the Laken Riley Act. And we'll kind of talk about the specifics in a little bit, but essentially what happened is it got a lot of press in terms of what it was, what the bill was introduced and trying to do during the course of the election. This the election season of September, October. Um, Essentially, finally, the bill was passed. So it was passed in the House in January. Uh, I would say I wouldn't call it a 100% bipartisan bill, but there were 216 Republicans who voted yay for it, 48 Democrats who voted for it, and then it was passed in the Senate by a count of 64 to 35. So there were 10 Democrats who voted yes, including John Fetterman from Pennsylvania, and Mark Kelly from Arizona. So a lot of kind of high profile Democratic senators also supported the bill. So that's kind of the history. It was really in the news. I think Marjorie Taylor Greene kind of brought it up during election season, and that's kind of where we're at. And it was ultimately signed in uh, by President Trump last week, making it law.
Yeah, and very notable that this bill ended up being the first first bill passed by Congress to be signed into law by President Trump, at the beginning of his presidency. Justin, what were some of the provisions that were included within the Riley Act?
Yeah, so some pretty big provisions. One is I'd say the major one. Well, there's a couple major ones, but um, the act it amends the INA to essentially have theft include burglary, larceny, and shoplifting to require states to mandatorily detain folks who are either arrested, charged, or convicted of those offenses. Um, Before there was not mandatory detention for such thing as shoplifting. So if an individual, and we'll kind of talk about who this applies to, is charged, arrested, or convicted of something as little as shoplifting, a state has to mandatorily detain the individual. I would say regardless of if it is an offense that would render them removable from the U.S. So I think that's kind of one of the big things in here. The two other items that I would call out is um, it gives states attorneys general the ability to sue DHS if there are um, anything over $100 that impacts the states. Um, I think legally speaking, there could be a lot of things that could fall into that bucket in that category. And then I think the big thing here is that it really transfers the power from the federal government to the states um, to essentially revoke or take away visas from certain individuals. I'd say the biggest thing, and we'll kind of talk about how this applies in the mobility context, is um, if states are seeing that countries are not accepting individuals who've been removed from the United States, who've been found to be removable, states can sue, and ultimately, under this provision, under this law, um, there would be authority to then revoke visa statuses for those individuals. I'll give you an example. Um, Maybe a certain state sees that there's 1,000 or 5,000 Chinese foreign nationals within the state who've been ordered removed from the United States, and China itself is not accepting those individuals back. They're not producing the travel documents. That state, the attorney general in that state could actually sue and have those visas essentially canceled out for individuals from that nationality. So it could impact students, it could impact H-1B holders. So it has kind of a wide-ranging impact of individuals that could be impacted by this. The one thing that I would say I think that I would kind of call out here is that I read a lot of articles and a lot of interpretations about the Laken Riley Act, and everyone has kind of their own take in terms of how little or far it could go. So the bill was written in a way to really apply to individuals who enter the United States without documentation. So if you cross the border illegally and then you get arrested for shoplifting, you go into mandatory detention in a state, which previously you would not. But the way that it was drafted, it also could apply to individuals who are paroled in the United States. So humanitarian parole, it could apply to individuals who have DACA status, and it could also apply, kind of reading some articles by some legal scholars, it could also apply to individuals on non-immigrant visas who have advanced parole, so they're waiting green card applications and in the employment queue, and they're traveling in and out of the U.S. on their advanced parole. So it could impact those individuals. Anyone who is charged, thought of committing something like shoplifting could be subject to mandatory detention.
Yeah, and this, and this issue of the expansion of state powers, related to immigration is not a new one, and we've seen a number of cases and litigation that's come up in recent years related to this. But but this is really the first major case where you've seen congressional action, related to, addressing this issue of state power related to immigration. And you
Yeah.
brought up a number of examples of sort of, how this could, potentially open the door for other areas, of immigration, not necessarily intended, under the Laken Riley Act per se, but with this act and, now becoming law, what areas would you recommend talent mobility professionals keep an eye on, or, how should, mobility track and see how this gets operationalized and put into practice, now that it's become law?
Yeah. So I think individuals, who are managing programs need to take a look at, this could apply to, individuals who are working for you on TPS, who are on DACA, even individuals who are on H-1B who have advanced parole, who are using the advanced parole to come in and out of the country. I think one of the scary things is because it applies to such, small things like shoplifting, individuals could be charged with shoplifting. They could be arrested and then subject to mandatory detention, for I'd say a long duration of time until immigration comes in and there's kind of, I guess, further litigation in regards to their own case. So I would say that I think it's very important not only just to be aware of it, but also kind of in the duty of care context for the individuals who are working for you. The larger, I think, issue is, how this is going to be carried out, within states. I think kind of the example that a lot of scholars have been giving is, so say you have, a governor or a state's attorney general who is noticing that there are the example that I gave before, Chinese foreign nationals who are not being removed, they could ultimately sue the federal government and then move to have the visas for H-1B holders who are working in say, Texas, for example, all canceled out. Um, and I think one of the things, kind of reading articles about this and the various interpretations is no one knows how far it could go. Whether if a state sues to have visas revoked, whether that's Fs, whether that's H's, whether it could be applied to a federal, injunction or revocation of those visas, or whether it's applied to the state. I think folks don't know, but I think mobility professionals need to understand kind of the severity of this. The fact that the power has been transferred to the states, and need to understand kind of, the kind of the forces at play here in terms of there may not be, you know, bills that are passed or agency, decisions that are made by the Trump administration, but there could be sweeping changes, from an immigration perspective brought on by state lawsuits. And I think that that's the thing that could really impact business here is not only your own individuals in terms of how they're being treated, or the potential to be detained for certain small things, but also kind of the big scale, what's going to happen if states, governors and attorneys general start suing to try to revoke, say, H-1Bs. I think that's the big thing to keep an eye on.
Great. Thank you so much for sharing your insights with us on this, Justin.
Absolutely.